Great, it looks like we are live. Hello, so I'm so happy you're joining us for this live stream where we are going to talk about the AI Act. So, about the European Union's plans to regulate artificial intelligence. I am Letitia Parcalabescu. I'm a researcher in AI, and I'm also running the AI Coffee Break YouTube channel where I explain latest research in AI. So I am aware that AI can create many benefits, such as better healthcare, more efficient manufacturing, and so on. The list can grow much longer than this. But at the same time, as we rely more and more onto AI systems, it can pose potential risks. So I was very excited when I saw that the very important step that the EU is taking now when it comes to AI, the European Parliament plans to regulate artificial intelligence with the intention to ensure that this technology helps us for the better and keeps us safe from the worse. So I thank the European Parliament for the opportunity to be here today, because what is a better chance to learn more about the AI Act other than from the Parliament members in charge of the AI Act, Mr. Brando Benifei and Mr. Dragoş Tudorache. I'm so excited about this. So, Mr. Benifei and Mr. Tudorache, thank you for speaking with me today. And maybe we can start slowly to get everybody on the same page. Can you tell us crisply, in a nutshell, what are the main points of the AI Act and what does it mean that it is a risk-based regulation?
Well, maybe I can start. Thank you for this opportunity. Well, the AI Act is the first ever regulation of this kind in the world. In fact, we have similar ideas all over the world on risk reduction. That is the core of this regulation, but this is the first time we put it in a legislation. It's not a voluntary code, it's not a recommendation, it's law that can be enforced, that can defend the interests and the rights of citizens in a higher level, for sure. The core of this legislation, the idea behind it, is the fact that we should have a human-centered AI developed in Europe, that we should defend our values, our model, and also build a dialogue with the rest of the world around how we can make AI compatible with democracy, supportive of emancipation of people, of giving more opportunities, and not instead create more fractures or fuel disinformation or create a control state. We have been working on that, and we built a risk-based approach that identifies high-risk AI use cases that needs to be more regulated, that needs to be checked on data used to train it, the human oversight, the technical requirements that are there to mitigate and reduce risks for people, for their health, their safety, their fundamental rights. And we also identified uses that we think should be outrightly banned, like the use of biometric identification in public spaces on real time, to avoid, by banning it, the risk of mass surveillance. And we also banned predictive policing, social scoring, emotion recognition for students and workers, because we think that in these cases there is no added value and more risks than benefits. So we built this architecture, and these, I would say, are, from my side, the gist of how the AI Act is organized and how it is defined.
Thank you very much. I think it is a great idea to go and say, yeah, let's ban specific use cases and let's regulate specific use cases, rather than saying, let's stop all AI that is doing computer vision, so the kind of AI that processes images or video, or let's ban language models, so all of the AI that processes natural language. And it's right to identify these cases where you want it to be banned, and cases where you want just to have a look over it, and some cases that are just fine and should just be going on like they do. But I'm very curious, what exactly falls under the category of AI? Like when does a face recognition system come into this category of AI, and when is it regulated?
Well, we have a definition of AI, and I think that is a starting point, and it hasn't been easy in the negotiations in Parliament to find common ground on how to define AI, how to differentiate AI from general software, because there is already quite a broad range of very complex software out there, but which is not AI. And we wanted to be very clear and very, very sharp in the way we define AI so that, again, we not unnecessarily cover software that should not be covered by the text. So AI, in the view of the Parliament, but we are also consistent with what the Council has adopted as more or less, still some nuances to be defined and to be negotiated, but more or less we're on the same page, which is to recognize the fact that an AI has to work with a certain degree of autonomy. And in the content that it generates, it has to be able to influence or capable of influencing either virtual or physical environments. And that is the key element that differentiates AI from other type of software. So whether we look at applications that are in the prohibition list or applications that are in high risk, we have to first make sure and differentiate and make sure that it is indeed AI and that it comes indeed under the scope of the regulation before we determine whether it is one of those applications that would be prohibited or not. And the same stands true for biometric identification.
Mm-hmm. And do you think that if a company releases a technology, do you need to look inside into, let's say, the code or its infrastructure and its data to decide whether it's AI or not? Or can you just know that something falls under the AI regulation by seeing how it works, like measuring this autonomy part? Because otherwise you would need companies to disclose their technology, and maybe they can or if they hide it, they just say, yeah, it's an if-else program. It's not a deep neural network.
Well, we are working on the assumption of self-assessment. This is the underlying rule that we have introduced in the text. So companies will self-assess, and they will self-assess on the basis of the definitions that are in the text and the criteria that are in the text. And it is then, if their determination is that they are in the category of high risk, then there are obligations that have to do with transparency and indeed with explainability, which means that they will have to explain what kind of data they use to train the algorithm, what kind of instructions did they give to the algorithm, so on and so forth. We don't ask them to disclose the code itself, because that might even be protected by law. But we're asking them to give those technical elements and to describe the functionalities of the system that would allow people to ultimately do what? To ultimately trust the system. Because all of these obligations that the law introduces are meant to introduce trust, so that we as consumers, we as end users for these systems, have the confidence that when interacting with these AI algorithms, our rights are not affected. So that's ultimately the philosophy that the law follows.
Okay, great. So I see it's a self-assessment basis from the companies, but also I was wondering whether there will be some technical experts that keep track of the development and propose adjustments, for example, to the law if needed. And will there be an office that would be where one could report possible infringements if, let's say, a company doesn't do self-assessment in the way they should do it?
Yes, for sure. The issue of flexibility of this legislation has always been at the core of our attention. As you mentioned earlier, the fact that we focus on use cases, it's important rather than just on the technology itself, because this will make this legislation more durable and less at risk of obsolescence. But at the same time, we have foreseen various degrees of facilitation for the modification of the areas that are under the high risk classification, the articles themselves. So we will need to negotiate still with the member states on the exact technical arrangements, but I think we share the idea that we need some flexibility in the way we can update and modify the legislation more quickly, so to adapt to further changes. But also we can say that we are working all the time with the technical experts, with stakeholders from academia, from the businesses, and we also foresee for the AI office, we call it, that's the evolution of the AI board that was foreseen by the European Commission, to engage with these experts and do its part in coordinating the work of the national supervisory authorities. This aspect on which I have to say also, especially colleague Tudorache worked a lot in the drafting that we have made of the governance and enforcement is crucial, because if we do not get it right, so that we have a good combination of a European coordination and execution when necessary, and the national authorities to talk with each other, coordinate, so that we can identify infringements, we can identify when the rules are not respected and people can be damaged, they can be exposed to a risk. Then if we don't do this correctly, then the law stays only as a paper. Instead, as we give confidence to the developers that they do self-assessment, at the same time it's important that we have our ways to check if everything is right, and that the institutions can do their part so that the law is actually applied.
If I might add,
Okay,
Eddie, one point on this, because you use the word expert, and I think this is one of the fundamental points in securing indeed the successful implementation of the law. Because it will matter a lot whether the national authorities will manage to find the right experts, underline the word experts, to be able to interact properly with the companies that will be developing these algorithms, that will be knocking at the door of the national regulator to ask questions, to interact with them maybe in a sandbox, because we have also provided in the law for the possibility of sandboxes. So again, the capacity of national authorities to secure these experts, to secure the expertise and populate the future national authorities with these experts is key, is fundamental for how the law will be implemented.
Okay, that's great to hear, and I hope that will work out, and that national committees will be formed from experts. I have another question related to like what regulation applies to, because it's kind of clear in everybody's mind that that if there's a huge company that wants to deliver its services on EU territory, then it has to comply to the AI Act. But does it even go to the level of a person? So let's suppose I want to make an Instagram post of something, and I want to generate an image with one of the latest neural networks. And does it even apply to me there, that I have to specify that that it is AI generated? Because if it doesn't apply to me, then why should it apply to, let's say, people who try to manipulate elections by doing Instagram posts? Or even, I mean, one can escalate this in a very bad way. So what is, at which, does it apply at individual level? And does it mean that everybody needs to highlight now that it generated something with AI?
I think the key starting point to understand how the law functions, and it's important to know that this is, or it has started at least at the beginning as a product safety regulation, which fundamentally means what? That if you go on the market, if you market a product, then the rules apply to you. And there, so if you put something on the market and as an individual using a system, you are not in that logic. But whether you are an individual that develops, big or small, an algorithm that has the potential of bringing about risks to someone, and falls under the scope of the legislation, then yes, that the law will apply to you as well, whether you are small or big. So the size of the company, whether one single person or a company like one of the big five, it doesn't matter. What matters is, again, whether the product or the service driven by AI that you put on the market, and that's the starting point, falls into one of the risks, and one of the risk categories that the legislation includes.
But then maybe a stupid question.
No, I can also add one thing on this, as you mentioned, the creation of a post. I can imagine maybe by helping yourself with a generative AI system, I can say that the parliament, compared to the original text, compared to also the work of the governments, has been more advanced in tackling in its version of the text that now will need to be confronted with the version of the governments to have a final text, has been more advanced, more open and clear on tackling the issue of the generative AI. So again, this goes back to those that develop the systems rather than you that are using it, but we have been putting some clear obligations, especially on, we can say, a form of enhanced transparency, because we want to make the content generated by generative AI systems to be identifiable as such, as a non-human generated content. We want to ask the developers to put all the effort to reduce the risks of creation of illegal content, to also make the deepfakes identifiable, because deepfakes risk to be the new frontier of mass disinformation. And this will interact also with another important piece of legislation, the Digital Services Act, that is entering into force and that governs what circulates in the online platforms. And finally, the copyright protection, because we have the legislation on copyright that is existing already at EU and national level. We do not change it, but we want to protect the rights, the existing rights of the authors and creatives that are being now in a difficult, in a weak position in front of systems that just digest all materials and use them for training, and then they produce also works of art, if we can say, but they are trained with materials that are not their own. So we need to find a balance on that. We need to make this transparent so that we can also see where there is the need for remuneration or compensation.
Yeah, I guess my confusion starts because I'm also a researcher, and for me it's kind of unclear when is a research product already just research and look, this is what I've done, and I publish a paper, and when is my code already a product? Because I could just say, look, I'm OpenAI, I just released this thing called ChatGPT, and you can use it and play with it. Does this mean that it's if I say it's research, is it already a product, or when does it really become a product? Do I have to request money for it?
Exactly. That's a very important point because we have two exemptions that we introduce in the law. The first exemption is for R&D. So in our view, research and development should be exempted from the scope of the law because, again, it is not yet something that is put on the market. And yes, put on the market to gain an income, for commercial gain, let's say. And then we also have an exemption when it comes to OpenAI. Sorry, not OpenAI, to open source AI. So open source AI is exempted from the scope of the regulation unless it is embedded in high-risk applications. So high risk and the element of risk remains central in the way the law applies and in the logic of the law. So even if you are open source, but if you are in a high risk area, then you will have to comply. But otherwise, again, open source is exempted just like R&D is.
Okay, great. Thanks a lot. And I see the time is pressing. So I have one final question. Like, what is the timeline for the adoption of the AI Act? Like, when do we have to think that the new AI Act will most likely become applicable?
Well, we are working a lot to conclude these negotiations in a short time because the AI Act is needed. We want it to become law soon, so we are hoping to conclude by the end of the year these negotiations to make it a final approval of this law at the beginning of next year. Then we have now foreseen 2 years' time before it becomes and it enters into force. So for now, it would be that it becomes fully applicable at beginning of 2026 with this timeline. However, we will for sure talk about possible shortening, partial shortening of this timing because it might look a bit too long. Maybe we can adapt it. And in any case, even if we don't change it, there are voluntary compliance initiatives going on. Especially, we can mention the AI Pact that is being built to, from the Commission side to make the AI Act being complied with voluntarily by businesses and public authorities before its entry into force. This would be especially important, for example, if we look at one topic that often comes up, the European elections of 2024. When will the AI Act be applicable to what will be happening around the elections? No, because it will not be entered into force, but it could be applied voluntarily with the AI Pact. And also, there is also an international level initiative, the AI Code of Conduct on Generative AI, that is the idea to, at least on generative AI, have some basic common rules at a larger international level in the G7 context or even further. And this is also an initiative from the Commission side that we support.
Yeah, and I guess that a lot of companies have quite some incentive to become future-proof by already starting to comply to this. So yeah, it's great. So thanks a lot, Mr. Tudorache and Mr. Benifei. Thanks for being with us today. And a big thank you also to our viewers for tuning in. And I'm really glad to have participated in this informative discussion. And I guess we are all curious to see how this will develop and shape society in the future. And I am hopeful that this will pan out successfully. So thanks a lot.
Thank you.
Thank you.
Bye-bye.